Namaste, good afternoon. Today we are starting our webinar and I am alone today. So I would just say that our subject today is the Supreme Court judgments and NCLAT judgments in the last 2 months. We have analyzed judgments, and based on our experience, we would like to discuss and share amongst all. So let me start with my sharing of screen. So friends, as you know, the subject is very important. Unless a practitioner comes across the judgments of Supreme Court and NCLT, it is very difficult to perceive what is the right action, what is the wrong action. Even for insolvency professionals, advocates, and all stakeholders, the judgments are very, very important. First, we will start with the judgments from Honorable Supreme Court. And of course, the rainbow paper, already everyone must have seen this judgment, must have analyzed this judgment. But I definitely would like to share with you my perspective. Now, this particular judgment, I would like to say that these are the facts which must be known very clearly. This was, first of all, this was against the state tax, state commercial tax, or GVAT. So the Gujarat value added tax or any state tax, in fact, this was the law where it was also mentioned in section 48 of Gujarat Value Added Tax Act 2003, which provides for first charge on the property of the dealer in respect of any amount payable by the dealer on account of tax, interest, penalty, etc. under the GVAT Act. Now, this was the section 48. However, the adjudicating authority and NCLAT both, they said that section 48 cannot prevail over section 53. So it is the state tax officer cannot become a secured creditor. All these two things, the NCLT and NCLAT, they held in this case. So in case we see the facts of this case, this recovery proceedings in this case, in fact, started long back. It was started in 2011-12. So that means it was an old demand. And second thing, that it was a demand which was crystallized by 2017, because see, the 2017 was the date of start of CIRP. So let's try to understand the date of start of CIRP was 12th of September 2017. The recovery 11-12, and in fact the recovery proceeding, this was in 2011-12 was the year of demand, and 2016 when the recovery proceeding started. And however, the attachment of the assets were done on 8th October 2018. So let's see, September 2017 was the CIRP initiation date. October 2018 was the attachment date. That means the attachment was done during moratorium under section 14, and probably this entire judgment does not talk about moratorium under section 14, because this particular asset was attached during CIRP, and section 14 was applicable. However, nobody raised this issue before Honorable Supreme Court, because see, the NCLT and NCLAT, they both in fact fought. They both gave their judgment on whether section 48 would prevail over IBC. No, and when there is a clash, the clash is between section 53 and section 48. So therefore, section 53 will prevail and IBC will prevail. So this was the basic issue. And also the second basic issue was whether there was an automatic first charge on the property. So automatic first charge on the property can be one thing that the Supreme Court has said. However, the facts are different. The facts are saying that the attachment was done during CIRP. So in case the law of automatic first charge is kind of sacrosanct, then why would the attachment be done? Therefore, the attachment is a separate process, and the having first charge on the property is another step. So what they are saying is the first charge on the property is written in the section 48. And secondly, there are provisions where the GVAT, under the GVAT Act, the properties of the dealer can be attached. So in this case, the property was attached in October. So in case of these two provisions, that means the automatic first charge is something which is a scenario in this case. So we can't say that the first charge was automatic. What we can say that the law provides for the first charge, so that means a security interest, and then it has to be implemented by creating by attachment order. So in this case, the attachment order was passed in October 28 during CIRP, and the order of Honorable Supreme Court does not talk about attachment during moratorium. That means this particular issue has not been decided by the Supreme Court, whether the attachment can be done under Section 14 by statutory authorities. Although there is a judgment now from NCLAT that the attachment can be done during moratorium by the enforcement agencies under PMLA, but these are commercial taxes. Commercial taxes would be different from PMLA. So according to my understanding, without attachment order, there would not be any security interest created on the assets of the corporate debtor. So first, the facts that we need to know, that the demand was pertaining to 2011-12. The recovery proceedings started in 2016. CIRP started in 2017. Attachment was done in 2018. So when this case went to Honorable Supreme Court, so they only decided one part, whether Section 48 overrides Section 53 of the IBC. So it is not a really case of overriding. What exactly it is a case is whether the definition of security interest covers the attachment. That is the basic issue. If the security interest definition, like in case we see the security interest definition, that is very clear. Now the security interest definition says that it is actually, let us even try to see 313. And if I take you to this section 313, so then we can even read from the Act itself, section 313. Section 330 and then 31. Section 330 says secured creditor means the creditor in favor of whom security interest is created. So that means everything is on security interest. So without security interest, the secured creditor. So we have to, first of all, cross the threshold of security interest. Then only we can consider ourselves as a secured creditor. Now the security interest means right, title or interest or a claim to property created. So it has to be created in favor of or provided for a secured creditor by a transaction. So there should be a transaction for creating a security interest which secures the payment. So the transaction can be, or the security interest can be created for securing a payment or secure payment or secure performance of an obligation, and includes mortgage, charge, hypothecation, assignment and encumbrance, or any other agreement or arrangement securing payment, again securing payment or performance of any obligation of any person. So provided that the security interest shall not include a performance guarantee, so that's okay. So what we are trying to see is that first of all, there has to be a transaction that has to be created, then it has to for securing payment or for performance of an obligation. So the definition of security interest would cover attachment, because the lien is created, interest is created on the property, claim is created on the property by way of a transaction, and then the transaction is the attachment order. So therefore, the security interest can be seen as a valid security interest. So once the security interest is created, the in fact, the state tax officer says that if my security interest is created, then I have the right to become secured operational creditor, which is permitted by the law, that the operational creditors can also be secured. So the state tax officer wanted that yes, it should be considered as state secured creditor. Now therefore the Supreme Court said that since it was a secured creditor and the RP has not taken into consideration their claim, their attachment, that has not been taken into consideration, it has not been provided in the IM also. Therefore, the resolution plan cannot be accepted. Though the resolution plan accepted by the adjudicating authority and the appellate authority is incorrect. So the primary issue is the security interest. So there are basically three issues that I want to say. Number one, the demand is crystallized. Number two, the attachment transaction of attachment has happened. Number three, security interest has been created. Number four, the operational creditors has a right to become secured operational creditors, and they would be treated, had it not been there, then in section 53. Had it not been there, then in section 53, it should have been secured. I will just take you to section 53. Section 53 says, let us see the section 53. It says the debt owed to a secured creditor. It doesn't say secured financial creditor. Debt owed to a secured creditor. And had this been the intention of the legislature to make only financial creditors can be secured creditor, but that's not a case. Any creditor can be a secured creditor. In the event such secured creditor has relinquished security in favor of this, matters are total in section 53. So when we say that there is a right of operational creditor to become secured by way of attachment, a lien or an interest on the property has been created, these two things will make the state tax officer as secured creditor. Once a state tax officer is a secured creditor, it will fall under the clause section 53 B2. So when it is section 53 B2, then will stand pari passu with the other secured creditors like banks and all. So therefore, according to my understanding, number two, the automatic lien, automatic charge on the property is really not a good, it's not acceptable. The three things should be there in anyone's case. Demand should be crystallized, asset should be attached, and then you can say that the state tax officer is a secured operational creditor and will stand pari passu with the secured financial creditor and will take proportionately whatever is being given to the secured financial creditors. The operational creditor who is also secured will get the same amount. So this is the entire case. Like they've already had that section 48 of the GVAT is not contrary. So this is, even we have known that there is a review petition filed by someone, and then IBBI has also made an application that the IBBI should be made a party to it, because they should be pleaded in this case, because it's a case of very high impact on the insolvency law. So therefore, IBBI have also impleaded in this case. So this very judgment, according to my understanding, even if it comes for view, I think the right of an operational creditor to be secured, that would be protected even in the review. In the meantime, we move on to the another judgment, which is K. Parmasivam versus Karur Vyasya Bank. It's a Supreme Court judgment on 7th of September 2022. And in this case, it's a case of Maharaja Theme Park and Resorts. It's a case where the applicant is protesting that the applicant is only a guarantor. It's a corporate guarantor, and the application under Section 7 is filed against the corporate guarantor, and it was admitted by NCLT, and the CIRP commenced. Appeal was filed before NCLAT based on the issue that the guarantor cannot be proceeded against, corporate guarantor cannot be proceeded against, and NCLAT, however, dismissed that appeal. Now it goes to the Honorable Supreme Court, and the Supreme Court says because the argument of the appellant in this case was again Section 3 subsection 8. Section 3 subsection 8, I can even bring it in front of you so that there is a clarity to everyone that what is the. So Section 3. Section 3 subsection 8 is the definition of corporate debtor. Means a corporate debtor who owes a debt to any person. Now the appellant says that I had only given corporate guarantee. The debt is not owed, it's not owed by me. The debt is taken by somebody else. So therefore the definition of corporate debtor in the IBC, I'm not fitting because I'm not owing a debt to any person. I'm not owing a debt to any person. This was the basic argument of the appellant. So the appellant said that I was only a surety in the contract of guarantee to a corporate debtor, the borrower not being the corporate debtor. So therefore, the Maharaja Theme Park and Resorts is not a corporate guarantor as defined in Section 5(5)(a). Section 5, subsection 5(a) also should be seen right away. 5(5)(a). Now it says corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. Who is a surety in a contract of guarantee to a corporate debtor? So that means it is saying the corporate person. So corporate person and corporate debtor, these two things are different. So when the question of corporate person and the corporate debtor, therefore the appellant says that yes, I'm a corporate person, but I'm not a corporate debtor, because the definition of corporate debtor again can be, so like let me even corporate debtor definition. Corporate applicant, corporate guarantor. Now, the definition says that when we talk about definition under section 3, subsection 8, the definition of the corporate debtor means a corporate person who owes a debt to any person. So the appellant said that it does not owe any debt to anyone. It has only given a corporate guarantee, but there is no debt on the corporate. So that was the argument, and then this argument was also like it was rejected in NCLAT 80. But then the Supreme Court also very clearly said in this section, Lakshmipati Surana versus Union Bank of India is a very famous case, and the Supreme Court applied and said that the Section 7 application can be maintained against the corporate guarantors, and this particular judgment says that the liability of the guarantor is coextensive with the principal borrower. So therefore, it was held that the financial creditor can move against the guarantor without first suing the principal borrower. So this was the decision by Supreme Court, and in this decision, the Supreme Court has held that the IBC proceedings can be started against corporate debtor. It can even be started when there are no proceedings against the principal borrower. So this is what the case regarding in the Supreme Court. Now another judgment, which is the review petition of Axis Bank Limited versus Vidarbha Industries Power Limited. Now in this case, Axis Bank Limited versus Vidarbha Industries Power Limited, the Supreme Court had actually given a very kind of controversial judgment where it said that it is not mandatory for the adjudicating authority to admit all applications filed under Section 7 of the IBC, because the Section 7 subsection 5 says that the word written there, first of all, it says that the Section 7 says that there has to be a debt, and then there has to be a default, and after that the adjudicating authority may admit the application. However, the objective of the IBC is to maximize the value for the stakeholders. Also, the objective of the IBC is to resolve the stress of the company. So the facts are that in this particular case, a kind of arbitration judgment which has already been passed in favor of the corporate debtor, and the corporate debtor is likely to get more than 1,700 crores, and the appeal has been filed by the other party, and that appeal was also pending with the same bench. The bench was convinced that in case this particular judgment is passed by me, so then this corporate debtor may get 1,700 crore of compensation as per the order already passed by the authority, which is an appeal before the Supreme Court. In that case, all kind of financial stress of the company would be resolved. The company will come immediately as a healthy company and solvent company. Therefore, the admission as a CIRP, admission of CIRP would cause irreparable loss to the corporate debtor. Therefore, the Supreme Court took a decision that it is not mandatory. So therefore, it is a right case where we can say no to admission. However, NCLT has erred. They have not understood the main objective of the IBC, which is maximization of interest and also the resolving the financial stress of the company. Now, when we talk about this is when I have already given you the judgment, and after this judgment, now let us see what is said in the review. The review says, the review is, I will just come to the review only. Review petition, and this is the petition number 1043 of 2022. The Honorable Supreme Court analyzed the following para of the judgment. the adjudicating authority has clearly acted outside the terms of its jurisdiction under Section 7, subsection 5 of IBC. The adjudicating authority is empowered only to verify whether a default has occurred. If a default has not occurred or the default has not occurred, based upon its decision, the adjudicating authority must then either admit or reject an application respectively. These are the only two courses of action which are open to the adjudicating authority in accordance with subsection 7.5. The adjudicating authority cannot compel a party to proceed before it to settle a dispute. So, therefore, the contentions of the learned Solicitor General in this case was two courses of action are available to the adjudicating authority in a petition under Section 7. The adjudicating authority must admit the application under clause A, subsection 5, or it must trust the application under clause B of subsection 5. The statute does not provide for adjudicating authority to undertake any other action but for the two choices available. It is well settled that judgments and observations in judgments are not to be read as provisions of the statute. Judicial utterances and or pronouncements are in the settings of the facts of a particular case. To interpret words and provisions of a statute, it may become necessary for the judges to embark upon lengthy discussions. The words of judges interpreting statutes are not to be interpreted as statutes. There are no grounds for review of this judgment and order. Now, the analysis says, when we say the analysis, the Supreme Court, by its order, in a way decided that the applicability of judgment would depend upon the facts and circumstances of each case, and for the decision to be binding for any other case, the courts shall have to satisfy that based on the facts, the decision of the Supreme Court in Vidarbha shall be applicable. The interpretation of Section 7 by the Supreme Court by itself cannot be looked as provisions under the code. So the Vidarbha is not a provision under the code. It all depends upon the facts of the case, and the decisions of Supreme Court are not binding on any case or other cases. So therefore, in case the three things are important. In case the adjudicating authority thinks that there is a better resolution available, and this IBC is an inferior resolution as compared to the better resolution available, then adjudicating authority can decide that instead of admitting it as CIRP, that better option for resolution should be activated, should be applied, and the time should be given to the promoters to use the other option, which is better. So this is the intent of this judgment, and it is applicable on case-to-case basis. The word may or shall should be considered as shall only, but in case of any circumstances where the CIRP is not a right decision for maximization of value for the creditors and for resolution of financial stress, then the cases may not be admitted. These are the two things. Otherwise, most cases would be admitted. Maitreya Doshi versus Anand Rathi Global Finance Limited, another Supreme Court's judgment dated 22nd of December 22. Now, in this case, an appeal was filed against the judgment and the order regarding the commencement of CIRP. The financial creditors were heard. In fact, in January 21, the CIRP was admitted, and another order, February 21, the adjudicating authority admitted the petition for initiation of CIRP against Doshi Holding for the same set of loans arising out of same loan documents in respect of which the financial creditor had initiated CIRP against Premier. So there are basically two cases. One is Premier Automobile and the other is Mr. Doshi, which has his personal company, which is the holding company, Doshi Financials. So let's take for Doshi Financial. So the basic argument for the appellant is that the Doshi is a guarantor and the insolvency cannot be started against the guarantor. He was not probably having any difficulty in insolvency of Premium, but this was the Doshi holding. It was actually the Doshi Holdings is the name of the guarantor. So in fact, it's KV Vishwanathan, a senior counsel in this case, argued, and it said that the financial creditor had not paid Doshi Holding any money under the loan cum pledge agreement. The loans were provided to Premier by the financial creditor. Premier received the loans that was disbursed. None of the funds provided by the financial creditor under the loan were used to holding. Premier was the principal borrower. Doshi Holding was the corporate guarantor, and even maybe it's a co-borrower. Let's see the facts. So Vishwanathan argued before the adjudicating authority that authority misconstrued the expression financial debt in section 5.8. IBC or failed to appreciate the scope and ambit of the said expression. The definition of financial debt in section 5.8 of the IBC does not include a pledge. Now, Mr. Vishwanathan further claimed that the adjudicating authority failed to recognize the distinction between the obligation of a pledger and a guarantor when referring to Doshi Holdings as a co-borrower and guarantor under the loan cum pledge. So in this case, in fact, the Doshi Holding was somehow, it was considered as co-borrower, and the co-borrower can be proceeded against. That's what is the final judgment of the Supreme Court. The co-borrower can be proceeded against. And also in case some shares were also mortgaged against this corporate guarantee. But finally, the Supreme Court, Honorable Supreme Court said that in the case of corporate guarantor, in the case of joint borrower, co-borrower, the IBC proceedings can be started against one and all. IBC proceedings can be started only against the guarantor and not against the main principal borrower. So this is all finally the Supreme Court has decided that it is not really, they are not giving any exemption. They are not giving any exemption to the guarantors. The guarantors are, in fact, so both the corporate debtors can be proceeded against. The CIRP can be started for both under section 7. However, they have to say that whatever is realized from one, that will not be claimed from other. Now, for example, the Joshi Holding comes into CIRP first, and the creditors are being given good amount, and then that money would be reduced from the claim in this second company. However, the CIRP can be started for both the companies. The amount can be recovered from both the companies. However, if one amount is recovered, so the balance outstanding must be reduced so that claim also gets reduced and entitlement from a resolution plan also gets reduced. So this is what this judgment talk about. This is, I think, we can take just 1 minute water break, and I'll be just back in 1 Thank you. Welcome back. So now we go to another judgment from Supreme Court, and that is also 22nd September 2022, Ashok G. Rajani versus Beacon Trustship Limited. So this Supreme Court judgment, again the latest one, so there are many cases which are pending in the courts where the CIRP commenced and some kind of settlement arrived at, and the corporate debtor approaching or the RP approaching adjudicating authority or the appellate authority for recording the settlement and disposing of the matter. So this is also a similar case. So the appeal was filed by the corporate debtor against the CIRP order before the NCLAT. The appellant says, the appellant say to NCLAT that you dispose of the CIRP and record the settlement. Now, NCLAT, instead of doing this, NCLAT, what it said, NCLAT said that the CoC would not be constituted. And also NCLAT further permitted the IRP to issue publication and also hand over all the assets and proceeds with the CIRP, even though the matter had been settled between the parties. Now, being dissatisfied from the NCLAT, so the NCLAT did not record the settlement and dispose of the matter. Rather, NCLAT said that the CoC would not be constituted, and the issue is that however the IRP will continue to for other things. So the issue, in fact, before the Supreme Court was, before the Committee of Creditors is constituted, is there any bar on the withdrawal by the applicant of the application admitting the undersection? So there is no bar. In fact, Section 12A of the IBC clearly permits withdrawal of an application under section. So see, this is where it has been admitted and application made by the applicant. So the question of approval of the Committee of Creditors by the requisite percentage of the votes can only arise after the CoC is constituted, but before the CoC is constituted, there is no bar on the withdrawal. So in this case, again, finally, it was held that the application for settlement under Section 12A of the IBC is pending before NCLT. NCLAT has stayed the constitution of the Committee of Creditors. The order impugned is only an interim order, which does not call for interference. In an appeal under Section 62 of the IBC, there is no question of law which requires determination by this court. The appeal accordingly is dismissed. NCLT is directed to take up the settlement application. So there are two things which are settled in this case. One, that the interim order, there is no question of law in the interim order. So the interim order has got no question of law. So therefore, the Supreme Court dismissed this appeal. And while the matter was pending before NCLAT, however, the Supreme Court directed NCLT to take up the settlement application and decide the same in the light of the observation. So what is appropriate in withdrawal cases? First, the best thing is that it should be filed by the application should be filed by the RP and it should be supported by the applicant. The form FA, I think, has to be filled, and that form will come to the IRP. then that will be an application will be filed by the IRP, RP before the adjudicating authority, and the case would be withdrawn. However, for the sake of urgency, there are many corporate debtors, they actually would go hurriedly and they would seek complete withdrawal, but then sometimes the benches are not giving them complete withdrawal, and they would say the claims to be received first. So that's something which is rejected by the Honorable Supreme Court, saying that once the application for withdrawal is received before Committee of Creditors, then the Committee of Creditors has got nothing to do. If the application is permissible, then it should be permitted, and it should be disposed of. Now coming to the NCLAT orders. NCLAT orders are too many. I will see how many will be covering in this case. So the first one is very important: Commissioner, Central Goods and Service Tax versus East India Transport Company. Most of my fellow professionals, they are facing these difficulties, that in many cases the CoC is constituted by the operational creditors, and whenever it is constituted by the operational creditor, in many cases the government authorities are the largest claimant. So they will be the biggest shareholder, the voting share would lie with them. And in most cases, we have seen that the statutory authorities, they do not cooperate with the CIRP. They do not vote for any resolution. Even if they come to the meeting, they attend to the meeting, but they are not really they are not supporting the CIRP. They are not even voting for any resolution for approval. They are not approving the fee. They are not even appointing the IRP as RP. They are not even proposing a new RP. So they are simply saying no, or they are simply abstaining from the voting process. So this is one application which has gone to NCLAT, that the Commissioner of General Central Goods and Service Tax, they were not cooperating, and they, in fact, they were, although coming to the meetings but not voting. Then they have not approved the fee of the RP, and the one application they directed. In fact, in the first application, it was given directions to them that they should cooperate, but then they didn't, and finally the second application was also filed. Now the central the Central Board of Indirect Taxes, they are actually saying that there is a circular which is dated 22 on recovery and write-off of areas of revenue, and then they are saying that in that circular of Central Board of Indirect Taxes, that board has no power, and in that circular we cannot make any expenditure as RP fee or CIRP cost. So the operational creditor did not cast their vote. See, the CoC cannot deny to act under the law. So it was in fact, it was held in this case that the CoC cannot deny to act under law, and directed the CoC members to cast their vote in CoC. Now, in this case, further, despite the directions of in fact, I started speaking, but my mic was not connected. Let me come back to this segment. So, coming back to the NCLAT judgments, the one judgment which I said is very important is the Commissioner Central Goods and Service Tax versus East India Transport Agency. It is NCLAT judgment dated 30th of September 22. So in this case, what is the issue involved? The issue is that the most, and then there is a settlement between the applicant and the corporate debtor, and that settlement is recorded by the adjudicating authority, and the withdrawal is permitted. This is a normal process. So in this case, what the settlement was, it was like there's two things. One, that there was settlement was to be recorded by the adjudicating authority. However, before that the corporate debtor filed an appeal before NCLAT, and in that appeal saying that the settlement is reached. So NCLAT, instead of disposing of the case, NCLAT said that the committee would not be constituted. However, the IRP will continue to publish the notice. So this is what is the appeal. This is what it says, that the IRP would continue to So in fact, whatever I was telling, this was for this case of this was for this Supreme Court case. This was for Ashok G. Rajani versus Deccan Trustship Limited. So this is what I was trying to tell you, but it was not NCLAT decision. So because the NCLAT said that the committee would not be constituted, but the IRP would continue to function, and publication would also be done. So against this order of NCLAT, the corporate debtor went to Supreme Court, and Supreme Court finally held that since it is an interim order, there is no question of law. So the matter should have been disposed of by the adjudicating authority, directed the adjudicating authority to record the settlement and matter be disposed of. So what has been done hurriedly? One, immediately on CIRP admission, the appeal was filed before NCLAT, whereas the settlement has to go to adjudicating authority. Now, when it came to NCLAT, NCLAT said, okay, constitution of committee is stayed, but the IRP will publish. So this is against this interim order. The corporate debtor went to Supreme Court immediately to get some relief, otherwise the publication would be done. And however, the Supreme Court said a reason out of the interim order, but then they directed the adjudicating authority to pass that order. So this is what is the what we can take home from this case, that the best course of action is that the application should be submitted by the IRP on a settlement on receipt of Form FA, and that's the best course of action. So in case any corporate debtor takes multiple actions, filing appeal before the NCLAT also, and also getting the settlement done, that may create this kind of problem. Coming to the NCLAT judgments, this judgment, I think since most of the state tax authorities or central tax authorities, they are not cooperating in CIRP processes. This is one case which is dated 30th of June, 30th of September 92. In this case, from the operational creditor, and the largest share was with the Commissioner's Central Goods and Service Tax. So what this statutory authority was doing, they were not cooperating. They did not vote on the resolutions. Neither they approved the fee of the IRP, neither they appointed any IRP, nor they replaced the IRP. So this is what was the basic difficulty. So the IRP went to the adjudicating authority, and in the first application, it was directed to the tax authority that they should cooperate, and they should also vote on the resolutions, and they should also pay CIRP cost. Now the CBIC Master Circular says, and this circular is again 19th of January 22, circular number 1081, and it was basically on recovery and write-off of arrears. Recovery and write-off of the arrears of the revenue which do not provide for payment of fee and CIRP cost. In this case, even the second application has to be filed, and finally the NCLAT very clearly said that the CIRP cost has to be paid, the IR fees has to be paid, and the circular is not applicable in this case. And even the tax authority also said that they are not interested to run the CIRP process and prefer to go for liquidation. This was also agreed by the other second statutory authority like the Assistant Commissioner of Income Tax. And with 98% voting, it was taken on record that the company may be liquidated. However, while the application for liquidation was allowed, NCLAT directed the operational creditors, that means the two departments, one is the Commissioner Central Tax and Service Tax, and also the Income Tax, that they have to pay the CIRP cost and they have to pay the RP fees also. So, and also they said that the CBIC master circular is not applicable in this case. So it has to be completely paid by the departments. And these are the so the CIRP cost has to be paid. This is one judgment, and we are moving on to the other judgment, which is Dr. C. Bharat Chandran, erstwhile promoter and a resolution applicant, Trivandrum International Health Limited versus MS and Research Center Private Limited, 19th October 2022. Now, in this case, the CD was admitted to CIRP, and in this case, the appellant, who is the promoter of the company of the CD, along with two co-applicants, had submitted a resolution plan for revival of the corporate debtor. So first, RP said that he is not eligible to submit. However, the appellant was permitted to submit the resolution plan by the adjudicating authority. So this was the first stage of litigation. The IRP or RP said that the promoters are not eligible. However, the benefit of MSME went to their favor, and they were allowed to submit resolution plans. Now, the appellant failed to furnish the bank guarantee. Even if the resolution plan was approved, the appellant, who is a promoter, along with the two resolution applicant, submitted the resolution plan. However, they failed to furnish the bank guarantee prior to submission of the resolution plan on account of the fact that the co-applicants declined to cooperate. Since the bank guarantee is an essential prerequisite of submitted resolution, the committee of creditors authorized the RP to file a liquidation application. Now, when the liquidation application is being heard, again the promoter filed another application, praying that the committee of creditors be directed to consider and accept amendment to the resolution plan in terms of the replacement of. So then he said that the co-applicant that I chose earlier, applicant, and the committee of creditors be directed to reconsider my resolution plan. That is what is the application which was again filed. In the meantime, the time period for completion of the CIRP was almost over. The tribunal observed that the time was insufficient to call for a fresh EOI, and according to the regulations, therefore the appellant, along with the new co-applicant as well as another party interested in submitting a resolution plan for revival of the CD, who had filed an application before the adjudicating authority and whose name had not been previously included in the provisional list of or final list of the applicants were directed to submit their EOI. So committee of creditors evaluated the resolution plan of both the parties at the next meeting, and neither plan received 66% minimum shares, and the resolution plan failed. Setting aside of liquidation of the corporate debtor, passed an interim order relying on the regulation directing the CoC to re-vote only on the resolution plan. Now, the adjudicating authority somehow is not agreeing to liquidate. First, the adjudicating authority cooperated with the promoter along with the two litigant and the CoC rejected. Then again, the promoter came to the adjudicating authority saying that I have some other people who are interested, so I should be permitted to submit an application so that I can revive the company. Again, the revoting was permitted. Now, the question which actually went to NCLAT, whether the adjudicating authority has no jurisdiction or authority to analyze or evaluate a decision of the committee of creditors to inquire into the justness of the rejections of the resolution plan. So this is the, like, these are the applicant says something, and what is held by the appellate tribunal. The appellate tribunal note that it was quite evident that the adjudicating authority did everything under its command and available options within the purview under the IBC to avoid liquidation. So even NCLAT also supported that it is the adjudicating authority's effort to avoid liquidation is justified. So that means, like, multiple times adjudicating authority would be directing the CoC to try resolution. So this is what was also upheld by the appellate authority. The adjudicating authority gave fair and equal chance to both the resolution applicants to the extent of the resolution plan in tandem. However, both the parties could not do so. The appellant was extension of time, replacement of co-applicant, and opportunity to submit joint resolution plans with the other resolution applicant, namely Sabine Hospital and Research Center. Unfortunately, the appellant was not able to come out with a resolution plan acceptable to the committee of creditors. So these were the facts. So the appellate tribunal also noted that there was clear divergent view amongst the members of the committee of creditors on the last two occasions. The committee could not muster minimum stipulated 66% of the voting right to approve the resolution plan. However, CoC unanimously with 100% voting rights recommended for liquidation of the corporate debtor. The appellant tribunal is conscious of Katina of judgments of Honorable Supreme Court of India, including case Asidaran versus IOB, CoC of SR Steel India Limited versus Tish Kumar Gupta, Valal RCK versus Siva Industries and Holding Limited, where the apex court has given clear verdict that the commercial wisdom of committee of creditors is supreme, and there should be minimum judicial intervention by NCLT, NCLAT, and further it was held by the appellate authority in the SR Steel. In fact, again the reiteration, and even if the appellate authority say that it should be the liquidation should be the last resort, and as it tantamounts to tax null of the corporate debtor, however, it is also to be considered that the CIRP proceedings are required to be completed within stipulated period as stipulated in coming to end of the wall with no to be passed. Hence, it was clear from the above discussion that the adjudicating authority has no jurisdiction or authority to analyze or evaluate the decisions of the CoC to inquire into the justness. So this is what the case is. 2 times the liquidation was rejected. The NCLAT tried that it should be seen, but the finally NCLT has to say that the adjudicating authority has limited powers and the powers are not to interfere into the commercial wisdom. At the most, adjudicating authority can only see that the process has been conducted precisely and there has not been any unjustified thing done with any stakeholder. Going to one more judgment, Almas Global Opportunities Fund SPC versus CA Kalan Thurvangadam, NCLAT, date 21st of October 22. So in this case, the appeal was filed by the successful resolution applicant against the order of by the chairman of the monitoring committee was allowed, providing for forfeiture of the entire bank guarantee given by the appellant with the direction to exclude. So the successful resolution applicant filed an appeal. Because the chairman of the monitoring committee, provided for forfeiture of the entire performance bank guarantee given by the appellant with the direction to exclude the time from the date of issuance of Form G till the date of passing of the order and issued certain further directions. The appellant agreed by the said order had come up in the appeal. The application under section 9 was filed against the corporate debtor EMC Limited, which was admitted by the adjudicating authority and resolution professional was appointed. In pursuance to the issuance Form G, 4 expressions of interest were received, 1, 2, 3, 4. The resolution plan submitted by the application was approved by the committee with 80%. The appellant only made payment of 30 crores, which was towards the earnest money deposit, and performance bank guarantee was received from the appellant. In subsequent meeting, the monitoring committee, it was repeatedly stated on behalf of the appellant that they shall be depositing the amount as per the resolution plan. However, the appellant failed to comply. Now, in this case, the chairman only filed the application to NCLAT. This application was objected by the appellant. It was requested the time be granted to the appellant for it to fulfill its obligation. So the successful resolution applicant asked for time. So on the failure of the appellant to comply with the payment plan, adjudicating authority passed the impugned order allowing the forfeiture of the bank guarantee. So there are two questions which actually was raised in this case: whether the chairman of the monitoring committee has a locus to file the application under section 333(3), whether the adjudicating authority, while under the code, has the jurisdiction to return a finding of an offense within the meaning of section 74 of the IBC. So I know the fact. First of all, it was upheld that the chairman of the monitoring committee is responsible for monitoring the implementation of the resolution plan. So therefore, in case any contravention has happened, the chairman of the monitoring committee has done a right thing by informing the adjudicating authority that there is a contravention. So it was not said that it is the duty. In fact, it is the duty of the stakeholders, creditors whose interests are adversely impacted. But in this case, the monitoring committee, chairman of the monitoring committee filed, but it was upheld by NCLAT that it is his duty to do that. And secondly, since the adjudicating authority also said that it is a case of offense under section 74 of IBC, but it was actually held by NCLAT that the adjudicating authority has no power to pass any order on section 74, and the order of section 74 would only be passed under section 236 by special courts of the IBC. And no, the only thing that the adjudicating authority can make sure that the adjudicating authority can inform the IBBI, the IQ board, inform the board regarding such offense. However, even the central government can also be informed. However, any order on section 74 can only be passed by special court under section 230. That's what is for today, and we will start in the Sunday webinar in case we could find sharing some new subjects. Thank you very much for being with us. The webinar is concluded. Thank you.